Hi, hello. I'm Dr. K. Punguri, Assistant Professor in Department of Commerce. Now we are going to discuss about the subject commercial law. In that we are discussing about the nature of contract. Before going into the nature of contract, now we are going to see about the commercial law. Here, generally we can say that law means certain rules and regulations which is followed by the human beings or a human action, that is known as a law. It has a set of rules and regulation. Now we are going into a subject commercial law. Before that, the commercial law means is also a business law, we can tell it. It is a branch of law that governs the business, trade, commerce and commercial transactions over here. It regulates the rights, duties and obligations of a people and organization in a business activity. That is a commercial law. In this commercial law, the objective of this commercial law is to make to regulate the business transaction and also to protect the interest of trade and commerce and to ensure the fairness and transparency in a trade and to provide remedies in the case of breach of contract and also to promote an economic and social growth over here. So these are all the main objective of this commercial law. So you all understand what is a commercial law. So now we are going to see about, before entering into a contract or a commercial law, the meaning of a contract is most important thing. Here the contract means when two or more parties agree to do or not to do something that the agreement is legally binded, it is called as contract. So in simple way we can tell it that contract is an agreement which is enforceable by a law. So that is a contract over here. So if we want to take a contract means we all know that the contract is an agreement, and also we should need of two people. One people is offer and other people is an acceptant over here. Then only the contract is going to be a fulfilling. So next we are going to see about the different essentials elements of a valid contract. Before going into that, we should have a different elements over here that comes into a contract. The first thing is an offer, the offer or an agreement. Here the agreement or means both offer and acceptance comes together is known as an agreement. Here offer means one party must take a lawful offer to another party, that is known as offer, and the acceptance is the offer must be accepted unconditionally by another party, that is known as acceptance. Here the both offer plus acceptance is known as an agreement. The next thing is that it intention to create a legal obligations. So if you are entering into a contract means in that contract we should create a legal obligations. That is an legal obligations means we have to give a legal rights, duties over here. So that is an intention to create a legal obligation. The next thing is that lawful consideration over here. In this lawful consideration, the meaning of consideration means something in value or something in return, that is known as consideration for the promise. We have example, we can say that consideration, money, goods or services, etc. If we buy any goods from a shop, for example, if we are buying an attires from a shop, if we buy an attires, it is written to us, and for that we are paying an amount for them. So this is something in return. We are getting an attire from the shop and also we are paying an amount. The amount goes to a shopper and the dress comes to us. So that is a dress or an attires comes to us. That is a consideration. For each and everyone is having something in return. So that is known as lawful consideration. So next thing is that free concern. So free concern means we should not have any distractions over here. So everything should be clear. Example, we should not have any fraudulent activity, misrepresentations, mistakes, etc. This is known as free consideration. While if we are entering into a contract, we should be careful about all those things. The next thing is that performance of possibility. So we have to make a contract based upon their performance which can be the possibility over here. The next thing is that legal object. In this legal object, the purpose of contract must be legal. So there should not be any illegal or illegal activities. Example, an agreement is commit the theft is not a lawful. So it is not a legal object. So we should have a legal object over here. Next one is certainty of meaning, that is the capacity of a party. So that it is most important thing, parties must be legally capable of entering into a contract, then only we can make a contract over here. These are all the essentials point of a valid contract. So valid contract means which is enforceable by law, that is known as valid contract. Thank you. I hope you all understand about that, what is contract and what are the different elements of a contract over here. Thank you.